Ladies and gentlemen, today you heard Miss Rita Brown recall her interaction with the defendant here. You heard the traumatic event which consisted of this man pointing a gun at her for 60 seconds. 1 minute is not a long time. 1 minute of driving or talking or reading goes by in the blink of an eye. But 1 minute of your life on the line would be the longest minute of your life. A whole minute gives you ample time to look at a person's face and remember it. 3 weeks later, Miss Brown identified this man. For 3 weeks, his face was burned into her mind so strongly that she knew it was him the moment she saw him. Both encounters were in broad daylight. There is no question that she got a good look at his face both times. Now, the defendant claims he was not the man who did this. His claim is based on the testimony of his cousin, who he was supposedly with at the time of the robbery. There were other people around as well, but you did not hear their testimony. Only one person corroborated this story. Why weren't the other people called to testify? The defense has offered nothing regarding this issue, so we are left to conclude ourselves that they could not corroborate this story because it is not true. The jury instruction will say that in order to find the defendant guilty of this crime, it must be proven beyond a reasonable doubt. Based on the totality of the circumstances, what is reasonable? Sure, it's possible that someone else did this heinous crime, but that's not the burden. Based on the evidence, is it reasonable that this man did this crime? It is. There is merely a damaged alibi corroborated by only one person, the defendant's family member. Based on the totality of the circumstances presented here, there is only one logical verdict. The defendant is guilty of this crime. Thank you.
Ladies and gentlemen, this case is about a mistake. Not a mistake on the part of the defendant, but a mistake on behalf of the victim. Nobody denies that what happened to Miss Brown on the day in question is an atrocity, or that someone should be imprisoned and held at fault for that wrongdoing. However, my client simply isn't the man who committed that wrongdoing. As you've heard today, my client was at his cousin's house on the day the victim claims that he attacked Mrs. Brown. You've heard that he was sitting on his cousin's couch eating fried chicken at the time of this incident. The prosecution wants you to believe that nothing the defendant or his alibi say is trustworthy. But this simply isn't the case. The prosecution's only witness here is the victim. And the problem with that is that the victim is mistaken. The victim here identified a man who has admittedly gone to that bus stop repeatedly, rides that same bus every day at 8 a.m. to go to work and make some chicken for his community. The defendant lives only a half block away from that bus stop where the incident occurred. It would be unreasonable to think that the defendant would even consider robbing someone within such a close area to his own home. Rather, the victim has mistakenly identified someone who she lives close to. She lives only a block from the bus stop. My client, the defendant, lives only half a block from the bus stop. they've certainly probably crossed paths on multiple occasions. Maybe neither actually recognized the other. Maybe neither actually remembers the other. But subconsciously, the victim in this case has identified the defendant based on those interactions. This case is also a mistake on the part of the prosecution and the state in not having a photo lineup or any sort of lineup done after the victim identified the defendant. To be sure that she saw the right person at the bus stop and that she was identifying the person who attacked her on that day. Ladies and gentlemen, the prosecution's burden in this case is beyond a reasonable doubt. There has to be a moral certainty that the defendant, my client, a member of his community, committed this act. However, the prosecution simply cannot sustain that burden. Thank you.